Hi, and welcome to Celebration Bar Review. We're counting down, and now we're down to about 8 days. And that old Beatles song, 8 days a week, really makes sense, doesn't it? Because if we had 8 days a week all along, this certainly wouldn't seem quite as frightening. Now, most of my messages for the last few weeks have been a little bit more philosophical or esoteric and designed to help you with your mindset. Today, I thought that what we would do is taking a slightly different tact, a little more practical, if you will. Most of you are going to have to take essay questions of some of next week's exam. And I wanted to talk a little bit about what skills are being tested on the essays. And it really doesn't matter what jurisdiction you're in. I'm going to be quoting to you from the State Bar of California, obviously, probably the most difficult exam. And the examiners in this jurisdiction are trying to respond to what they perceive as happening with bar applicants. Their words reply to what we're doing here, I think, across the board. And they've been very consistent with what I see in other states like New York, Florida, Texas, Georgia, all the states that we teach in on the UB and around the country. In general, a lot of you are using this time when it comes to the state materials and the essays, and you might be trying to memorize the law, to learn more law, to get more law in your head, so that on test day you can go out and recite that law. You can put it on the paper or type it. Some of you call it regurgitation. Some of you are a little more graphic and just say, I'm vomiting on the page. Either way, it's not a very pretty picture. I feel very strongly about the writing style. In fact, I think a big part of the reason for our better than average passing rate for repeat bar takers is because we teach a style of writing that puts less emphasis on memorization and more emphasis on making arguments, on actually working through the material and showing the examiners how you would reason through and how you would literally take the reader through and make the arguments. So my message to you this week, and certainly at the start of this week, is don't be worried about memorization so much. Be more concerned about how you're using the law. Be worried about how you analyze. The State Bar in California, as I said, put together a description and a grading of the California bar exam. It's a pretty clear document, and I think it reflects their response to a pass rate that historically has been 40 to 50% or lower. What they're really saying in their description of the essay questions, I find fascinating. And so I'm actually going to read it to you verbatim with a few comments because I think that they are absolutely spot on in California. If you're not a California student, then let me just tell you, in this particular jurisdiction, they have 1 hour essay questions. But the truth is that the words that they say about these essays could literally come from what I've seen in any other jurisdiction. It's really different in a shorter answer jurisdiction like for the UBE or Georgia. But here's what the examiners say from their own document. They say that the essay part of the exam is designed to measure an applicant's ability to analyze legal issues arising from fact situations. If you're in our course, that word issues just makes my skin crawl, and you know that. So I'm going to restate that my own way, which is to say that this part of the exam is designed to measure an applicant's ability to analyze legal disputes arising from fact situations. But either way, notice what they say. It arises from fact situations. The examiners go on to say that answers are expected to demonstrate the applicant's ability to analyze facts of the question. That's the second time they've used that word to tell the difference between material facts, and the third time, and immaterial facts. So that's 4 times. And then to discern the points of law, and then fact. That's 5 times upon which the question turns. So in 2 sentences, they've used the word fact 5 times. Now, I know that there are people out there, particularly in California, who think that it's horrendous that anyone would write about the facts. It's interesting to me that the examiners use that word 5 times in the first 2 sentences to talk about what they want. In other words, they want to know if you can tell the difference between what's relevant and irrelevant. You go about writing about disputes and then to discern, I love that word, discernment, because that's very different than a memorized checklist or an attack outline, to discern the law. In fact, which turns. In other words, can you figure out what's important versus what's an issue, spotting size? And the examiners go on to say that the answer must show knowledge and understanding of the pertinent principles and theories of law, their qualifications and limitations, and their relationships to each other. In other words, you have to understand how the law works, how it relationship to the facts of the problem itself. Notice they're not saying anything about memorized law. Then the examiners go on to say that the answer should demonstrate of the applicant's ability to apply the law to the given facts. There's that word again. And the reason in a logical, lawyer-like manner from the premises adopted to a sound conclusion. And then they finish with this sentence: applicants should not merely show that they remember the legal principles, but should demonstrate their proficiency in using and applying them. Listen to what they said. It's not just showing that you memorize legal principles, but to demonstrate your proficiency. So how do you use a legal principle? How do you show that you're proficient in a principle? It seems to me the obvious answer is that you make arguments. You set up an argument and you support it with the law. It's that process examiners are looking for. Do that in your writing. You don't try and just put down rules of law. You don't take an attack outline and simply say, here's everything that I know about this subject, whether it applies or not. You show both sides of a dispute, and then you demonstrate and articulate how that works in the context of the particular problem that you've got in front of you. That's what translates to what happens here with 8 days out before the test. If you're planning on taking the next 8 days to do a lot of memorization, I think it's not going to be very helpful for you, no matter what course you're in or how you're trying to get through all of the material to get ready for the exam. The more effective thing to be doing right now is to think about how you would use the law to support particular arguments or positions to see how the law interacts. That might mean doing some practice questions. If you haven't been doing a lot of that, if you're in our course, it means going through and following the writing style that we've been teaching. But in addition, I really want you to know the law. You need to have the law, but simply putting the law down on the paper by itself isn't going to be sufficient. Going out and trying to issue spot, it isn't going to be enough. Now remember that that's not discernment. That's just, here's everything I know about this subject, and it's not particularly compelling. So use your time this week to think purposefully and to work in very direct ways. The examiners in California, I think, are speaking for all of the examiners when they say, look, we're just not interested in whether or not you have this skill of memorization. It's a skill that we no longer value in the profession of practicing law. It's like saying, I'm a great horse and buggy driver. Might be, but there isn't much call for it these days. There isn't much need for people who can memorize and recite the law. That's not what we're doing here. When I think about memorizing and reciting, I think about an actor, and you're memorizing and reciting your lines, really good skill. But for a lawyer to memorize and recite the law, not very useful at all. So don't waste your time doing that, and don't waste your time preparing for something that isn't going to get you much value on the exam. If you can do that, if you can keep your focus on what the examiners have said that they're really interested in, if you can write essays that show how you use the law and use it in supportive of arguments, you stand a very good chance of getting passing scores and doing well on the exam. And so I'll leave you with that at this 8th day. Be focused, be productive in your work, but do the things that are going to pay benefits for you in 8 days. And memorization, it's not on that list. Have a great study day. We'll be back again later this week as we get closer to your exam.